Okay, in this video, I want to talk to you about orders that you need to understand at the beginning of a divorce case. And the first one of those that I want to talk to you about is a TRO, temporary restraining order. And that's one that there's a lot of misunderstanding about. I knew a case years ago where somebody in the case was talking about, I got a restraining order put on the other side. In a Texas divorce, all it takes to get a restraining order put on the other side is, most of the time, to ask the court to put a restraining order on the other side. In a regular civil case, not a divorce, it is difficult to get a temporary restraining order. You have to prove certain things to the court. In Texas, under our Texas Family Code, they've made it very simple to get a temporary restraining order. So what is a temporary restraining order? Well, it is the first type of injunctive relief that a court can order in any case. And so what we're talking about is in a divorce case, a court can order a TRO at the outset of a case, and they can order it even later into the case, but usually you see these at the outset of a case. And it's an order from the court telling people mostly to not do things. They don't really tell people to do things. They don't order you to do things typically, although they can, but most of the time a TRO is to tell people things to not do. They're generally divided into three categories. Usually it's with regard to persons, with regard to property, and then with regard to children. And so with persons, usually what you see in a TRO is a set of rules that are telling you to not do things that are already illegal. Don't hurt the other side. Don't assault the other side. Don't harass the other side. Don't make prank phone calls to the other side. Don't do a whole list of things that frankly are not nice things to do and are probably illegal anyway, even if the court wasn't telling you in a TRO to not do them. So then you move on to the property. The property is different. The property is telling you to not do things that you would probably otherwise have a right to do. So the TRO may be telling you that you are not allowed to go empty a bank account and move money from one account to another. Without a TRO, you're perfectly free under most circumstances to go take all the money you want out of any account that you have access to and turn it into cash and put it under your mattress, or take it and move it to a different institution, or move it to a different account in the same institution, or any number of different things. But once the TRO is in effect, and once somebody is served with the TRO, then they are probably going to be prohibited from doing that. They're also going to be prohibited from doing things that possibly could be illegal anyway, like things that could lead to an obstruction of justice charge, or what we call a spoliation charge, which is not a criminal charge, but it's something that can come up in a case involving evidence. But it's going to tell people to not be hiding things, destroying evidence, destroying documents, deleting emails, deleting text messages, all of those kinds of things. So that can be the property side of the TRO that goes into effect at the beginning of the case. And then there are certain rules or orders with respect to children. And those are going to generally have to do with things like don't hide the children, don't stop the other side from knowing where they are. Generally, you're not going to have an order that's going to order you to give the children to the other side while the TRO is pending, but they will at least tell both people to not pick up and move, not change the residence of the children, things like that, until the court gets to the next stage, which should come up fairly quickly. Depending on the county, it may take a while. But historically, it comes up very quickly because by law, a TRO only lasts for 14 days. A TRO can only be in effect for 2 weeks unless it is extended, and it can get extended, and it is common that they get extended at least once. So usually you'll see a TRO, if it gets entered, you'll see it be in effect for 14 days or 28 days until and unless the court has a hearing on the matter first. But sometimes a TRO can get extended even beyond that 28th day. So in this day and age, one of the things that has happened, particularly in the large counties, is that courts have gotten so busy that they really don't want to get in the business of entering TROs. So what they've done is kind of come up with a shortcut and that's what they call standing orders. And so what these large counties have done now is they've created a set of orders that pretty much copy what would normally be in a TRO and what they used to enter all the time in the form of a TRO. And so what that says is once a case is filed, and usually what these counties say is when you file your case, you have to attach a copy of this to the petition. But once the case is filed, this standing order goes into effect in any divorce or SAPSR case, any divorce or custody case. And so then all of those orders apply to everybody that's involved in the case. Now, how do they apply? Well, the person filing the case is under that order at the outset because they're the one filing. They're aware of the standing order. And so theoretically, they have to govern their conduct according to that standing order from the time they file the case. The other side doesn't know about it until they've been served with it, or at least told about it, at least presented with a copy of it. And then theoretically, once they're aware of it, now they are under an obligation to comply with that standing order. What these standing orders do that's very different than historically what was done is they stop the parties from being entitled to a hearing within 14 days. When courts were entering TROs by law, as a part of the TRO, the court has to set the matter for a temporary hearing where both sides get to have a say in what goes on within 14 days. Well, as you can imagine, if you're in one of the large counties, the courts don't have time for all of that. And so what they did is they came up with this idea of, okay, we'll enter these standing orders and we'll just say this applies to everybody. And then we don't have to give you a temporary orders hearing for 3 weeks, a month, 6 weeks, 2 months. Who knows how long they can push it out. But the courts get to control their own dockets at that point because there's nothing in the law that mandates that they give you a hearing any earlier than that. So that can create a real mess because you can end up with a situation where one person or the other has taken the children or grabbed a whole bunch of money or whatever and then filed the case. And now these orders are in effect. And now the court's not going to give the other side any chance to get a remedy for any of that for a month or two. And that can cause a lot of problems. So we've talked about TROs, temporary restraining orders. We've talked about standing orders, which are usually just something that is meant to take the place of a TRO. And then the next step is generally what's called temporary orders. So temporary orders are that next type of injunction. A temporary order is a type of a temporary injunction. There are 3 types of injunction: TRO, temporary injunction, and permanent injunction. So a temporary order in a family law case is a type of temporary injunction. The TRO lasts from the time it gets put in effect until it expires at the end of those days we talked about, or until the court enters a temporary order. A standing order lasts from the time it goes into effect, which would be at the filing or the service, until the court enters further orders. But a temporary order, once it's entered, and again, it's a form of temporary injunction, lasts from that time until the court makes another temporary order, whether they call it additional temporary orders or amended temporary orders or whatever, or until the case goes final. And then once the case goes final, then those temporary orders don't govern anymore. So what do you see in temporary orders? Well, temporary orders are where you get things like temporary spousal support order, temporary child support order. You get orders that tell one side or the other that they're going to get the exclusive use and possession of the house, effectively telling the other side that they have to go find somewhere else to live. You're going to get orders telling the parties which vehicles they're allowed to control exclusively, those sorts of things. So a temporary order ideally is going to cover a lot of what's going to be covered, if not everything, in the final decree. It's just going to basically stick the word temporary in front of it. So with respect to children's issues, the decree deals with things permanently, if you will, or until the case gets modified. A temporary order deals with things temporarily. When it comes to property, the difference is on final, you're dealing with ownership. At the temporary order stage, you're dealing with possession. So you'll hear people, sometimes lawyers will have people come in and say, well, I want to hire you because I tried to represent myself, or another lawyer was representing me and didn't do a good job, and the judge gave my spouse the house. Well, when did they give your spouse the house? Well, they gave my spouse the house at temporary orders. Well, no, they may have given your spouse the right to use the house, but you still have your ownership interest in it until and unless you get divested of it in the final decree. And so you've got a lot of room between the temporary orders and the final decree to negotiate and do a lot of things to change that outcome that the person is worried about at that point. So we've talked about TROs, we've talked about standing orders, we've talked about temporary orders, and then a permanent injunction. An example of a permanent injunction that everybody is used to seeing is child support. That's a simple example of a permanent injunction, which proves the misnomer because it's not permanent because it's going to end at some point, but it's permanent in the legal sense, in the sense that it's in the final decree. Now, a couple things to be aware of. I said that most of the time a TRO does not order you to do something, but there are times when somebody can go seek what's called extraordinary relief. Usually you'll see that in the case of family violence. Usually you'll see that if somebody has been in a situation where there's been abuse of some type. And in that case, the one party can go in and ask the court to give them extraordinary relief and order the other side out of the home. And usually in that case, what you'll see is that other kind of order that people have heard about called a protective order. Now, a protective order is something that is an interesting term in the law because it comes up in two different circumstances and they're not at all the same thing. So there is an application for a protective order and there is a motion for a protective order. A motion for a protective order is something that is used in the discovery process. If the other person is trying to get me to produce documents that have nothing to do with our case. Maybe I was married to my first wife for 20 years, and I have all kinds of evidence that would have been from that case, but that case has been long since over with. My wife and I got divorced years and years ago, and now I've been in my second marriage for 15 years, and now I'm going through, heaven forbid, a divorce in the second case. And this wife that I'm now going through a divorce with says, well, I want you to produce all of your text messages that you had with your first wife during your first divorce case. The judge is probably going to grant me a protective order. I would like to hope they would grant me a protective order that says that I don't have to produce all of that material. So that would be something that is done following a motion for protective order, which deals with the discovery aspects of the case. An application for protective order is a whole nother animal. An application for protective order is something that comes up under Title IV of the Texas Family Code, and it's dealing with something that looks very similar to temporary orders, but it comes up when there's abuse involved and somebody is seeking to have the other person put under a set of orders that criminalizes their conduct. So when you're dealing with a TRO, temporary restraining order, or you're dealing with temporary orders, or you're dealing with a standing order, it's not generally going to say that one party has to stay so many feet from another party's residence or so many feet from the other party or can't go near the other party's employer or employment space or can't go to the other person's place of employment or things like that. It's generally not going to say in a TRO, temporary orders or standing orders, that one person can't contact the other person. But in a protective order, you're very likely to see that. And the difference in terms of result, if you violate a TRO, if you violate a set of temporary orders, is you can get held in contempt. The other person can file a motion for enforcement and a motion to have you held in contempt. And it's possible that you could get held in contempt. You don't pay temporary child support. You could get held in contempt for that. You could get sanctioned for that. Theoretically, you can get put in jail for that. But a protective order is very different. If you violate a protective order, the violation of a protective order is in and of itself a crime. So somebody may have committed a crime, spousal abuse, that then gives rise to the protective order. And then if they violate the protective order, they may not only be violating their bond that they're out on for the underlying crime, or if that case has already been taken care of and now they're on probation, They may be violating their probation, or if they've gone to prison and now they're out, they may be violating their parole or whatever. In addition to that, they are creating another criminal problem in that the violation of the protective order in and of itself is a crime. They can get arrested just for violating the protective order, and now they face that charge in addition to any other charges that they're facing. So that's the biggest difference between a protective order that you get following an application for a protective order, following family violence, and how a violation of a protective order is treated by the court as compared with a violation of a TRO or a violation of temporary orders. Theoretically, a violation of standing orders can give rise to contempt, just like a violation of a TRO and a violation of temporary orders can, although, in my opinion, there may be some constitutional problems with that because standing orders do not arise in the same way as a TRO or temporary orders do based on the things that we've talked about. But theoretically, a violation of standing orders can give rise to a motion for contempt and motion for enforcement also. I hope that helps explain the different kinds of orders that you can see in a divorce case, and particularly those that you tend to see at the beginning of a case. And so you need to be aware of those as you start looking at your options and start considering what's going to happen and what decisions, what choices you need to make at the beginning of your case.